So the Bush administration is really taking a chance here, because if in fact it turns out that they're not correct in their appraisal that this is perfectly legitimate, and some court decides that, they could throw all this information out, and in fact it would hurt a prosecution as opposed to going through the safer route, which would have been to create a safe harbor by going to the court and getting a warrant, which is almost never subject to attack.
Well, and already there are intimations, at least in some of the pending court cases, that people who have been prosecuted for, quote, terrorism, unquote, crimes or acts of material support of terrorism have been the targets for this very kind of surveillance. And there are now at least 5 cases that I'm aware of in this country where people who have been convicted or have been charged with terrorist crimes are seeking to at least have an inquiry into whether or not they were targeted. And if it turns out that they were targeted, and it also turns out that the program is illegal, those prosecutions are in serious jeopardy, whereas they might not have been if, as Kate suggests, the government had been willing to ask this court to give a warrant for those particular cases, because they look, at least on the basis of a jury's belief that a crime was committed here, they look as if they probably would have gotten a warrant for many, at least some of those cases, if not all.
This excerpt is brought to you by the Massachusetts School of Law, the leader of reform in legal education and a leader in multimedia education for the public. To view the full interview and for a full listing of MSL's programs, log on to mslaw.edu.